Good afternoon, ladies and gentlemen, dear friends of arbitration and mediation. I am very pleased to welcome you to the fireside chat for young law practitioners on standardized styles of international arbitration proceedings and their adaptation in Vietnam. This is the last webinar of a series on ADR hosted by VIAC and its partners. This series aimed at providing notable trends and key development of ADR in the post-COVID-19 world. In today's webinar, we will listen to the seasoned international arbitration practitioners and experts based in different jurisdictions as they discuss several themes related to young practitioners. The topics include, firstly, a summary on international arbitration proceedings and their common standardized styles. Secondly, we will have a very heated discussion sessions regarding proceedings adaptation in Vietnam. We will consider the approach of both international and adaptive to Vietnamese legal system. Since the webinar touches mainly to young practitioners and law students, it will be conducted in an interactive Q&A style. Therefore, viewers are encouraged to raise questions and discuss with them, with the panelists. We hope that the webinar will have a good starting point for those who are now seeking to build a career in international arbitration. Ultimately, we want to develop Vietnamese arbitration by creating a team of professional arbitrators and advocates. So now we'd like to introduce our distinguished panelists. Today's webinar will be led by our very distinguished speakers, Mr. Xuan, the chairman of HopDang Chamber and one of the VIAC listed arbitrators. And I'd like to invite Mr. Xuan will give the very brief keynote speech about the topic, and then he will have his panel with a lot of enthusiastic experts and practitioners to give us a lot of information. Mr. Hup, please.
Thank you. Thank you, Ms. Hung. Thank you, everybody. It's my great pleasure to be speaking at this webinar today. And I look forward to the interactive discussions with all of you, as well as with the panelists that we have in a moment. But before that, I've been charged with giving a short presentation, and I will now share my screen with you. Give me 1 minute. There we go. Okay. Right, I need to go to full screen. All in good shape. Right, so I aim to speak for about maybe 20 or so minutes, if I can manage. And then we will follow with the presentation from our panelists, and then then come the interactive sessions with the audience. So as I said before, I encourage you to start posting your questions, whether you've got before, you're thinking of now, or that those arise from the presentation by the panelists. Right, the subject matter of this afternoon's webinar is on standardized arbitration proceedings and adaptation in Vietnam. And I'd like, for the purpose of my presentation, I've got two things. As the title suggests, I wanted to touch on some of the standard practices, international arbitration proceedings, and then secondly, the possibility of adapting those, if at all, in Vietnam. Now, I think the word international in the phrase international arbitration proceedings, in my view, might be a little bit misleading in the sense that to some people, especially to those who have just started their work or study in international arbitration, this might suggest that there is only one particular model, there is only one particular style, there is only one particular way of conducting arbitration that is to be applied internationally. Well, let me dispel or in my view, dismantle that notion very quickly, because there is no such a thing. In fact, arbitration, even when you call it international arbitration, is actually quite specific to each particular jurisdiction. So if you have, say, 100 to 280 countries, then you might have 280 different ways of conducting arbitration all over the world. So there is no such a thing as one standard or one particular international style that one should follow. As it happened, a couple of weeks ago, I gave a seminar with Law Asia, where I spoke on the very topic of how to maintain certain distinctive features of arbitration of each country, and Vietnam included, because there are particular features that have been developed based on the relevant laws, practices, culture, experience of each particular country. You know, you might raise your eyebrows, you know, why are they doing that? But they've got their own reasons, and not to follow what might be called as international standards. England decided not to adopt the modern law by Dzungsrt, notwithstanding it's called the modern law, and some might even call it the international modern law. England chose not to adopt it, and England chose to have its own arbitration law, and so did we in Vietnam. We had our own arbitration law. I mean, there are a lot of similarities, but it is not the model law as such. Anyway, today, I'm going to speak on the flip side of the coin. I'm going to make the point that, yes, well, there are features that might be specific to particular jurisdiction, but there are, I think, general practices that have been applied internationally that has been built upon the wisdom, the experience, the knowledge of a lot of people all over the world. And to the extent possible, arbitration tribunals should, all over the world, should consider either adopting or adapting those practices in order to make the proceedings in their respective jurisdiction more efficient, suiting the very purposes of arbitration. So let me get on with it. I mean, and there are many of these. I mean, we can spend 3 days and we're still going through it. And we don't have 3 days. So I will only touch upon, I think, 3 points as examples of what I have seen from my personal experience, what is being done in lots of different jurisdictions. And I will advocate the proposition that arbitration tribunals and practitioners in Vietnam should consider adopting or adapting those practices here. The first practice is that there is a very important document that is often produced at the very beginning of the proceeding called the Procedural Order Number 1, PO1. Now, for those of you who are not yet quite familiar with arbitration practices, you start with the case start. I mean, of course, you have the arbitration agreement in the contract, which is the seed of the entire thing. But then once the dispute arises, you have the claimant filing a notice of arbitration or a statement of claim in Vietnam. And then the respondent submits a statement of defense. Now, after that, the tribunal is constituted. And after this, the tribunal gets together and talks to the parties and then produce a document called Procedural Order Number 1. This is an important document because it sets out all of the housekeeping, logistic, procedural issues, ranging from means of communication. How do we communicate? By email, by phone, hard copies, which number? What is the language to be used in the arbitration? Most importantly, the timetable. Who is going to do what? How, when? When is the hearing? What are the logistics? who prepares the stenographer, who engages the translator, and so on and so forth. So a lot of these procedural issues are dealt with. And it's very much like if you're going to have a big event, then you need a plan for it. You need to set out who's to do what and how to do it, so that when the event actually happens, there are no surprises. So it's just common sense in a way. Then after that, the tribunal issues the document, setting out very clearly all of these housekeeping issues to make sure that if everybody sticks to these points, to these procedures, the proceeding in the next 12 months, 6 months, however long it is, will take place smoothly with no surprises along the way. And it'll conclude efficiently as everybody expects. One of the important things about this is that it allows the parties to participate in planning the proceeding. And this doesn't happen when you're in a court proceeding. And this is an important point that there are a lot of differences between arbitration and court proceeding. And one of the key differences is that there is a lot more party autonomy in arbitration. An example of this is that you are able, as a party, to participate in planning how the proceeding is going to unfold. For example, hearing date. If you're in a court proceeding, you get sent a date. That's it, finished. You've got to turn up because the date's been fixed by the judge, and you have no say in it. Here, if you come to the discussion on procedural order number 1, when the hearing date is discussed, the tribunal would ask, how about the 1st of July, 2021? You might say, oh, I'm sorry, my son is getting married, or I am getting married, or whatever, right? Something on that date. I cannot do it. Can we do it the week before, the week after? So it gives the party a lot of room to discuss and agree on how the procedures will take place. Same with submission of documents. I need to put in an English translation of the law on arbitration, but it's too long. Only Article 4 is relevant. Can I just put it on Article 4? I don't need to pay for the entire translation. Maybe, why not? What about what do you think the other party? So you discuss it, you talk about it. And in an ideal world, the parties often come together and agree on these matters, and the tribunal will just endorse it, give it the blessing. So procedural order number 1 is very effective in that it allows the party to participate in planning the proceeding. It allows the proceeding to be conducted smoothly. There are no surprises, no adjournment. No one's going to turn out and say, oh, I'm sorry, on the 1st of July, I'm getting married. Wow. And you should have raised it at the procedural hearing. And therefore, this will maximize efficiency of the proceeding. Now, going back to all that may seem to be common sense, and of course, before you do anything, you've got to plan it out. I mean, it just why would you do that? While in the Vietnam context, it's still a bit different, in the sense that many cases are or appear to be very simple, and I think Vietnam is wonderful in the sense that we're very efficient. The claimant would start by filing a very comprehensive statement of claim, and the respondent will counter with a very comprehensive statement of defense. And in a particular case, there might be nothing further to submit. There's nothing more to discuss. All that needs to be done is the tribunal conducts the hearing and issues the award. So to many of these cases, having a preliminary meeting and having a procedural order number 1 is of no use, so the parties say, because there's nothing more to say. There's nothing more to submit. Why do we waste time with a procedural order number 1? So if, think of an example, if all you're saying is, let's have dinner tonight, let's meet at 6 o'clock in the restaurant and have dinner, when you don't need a pre-meeting to discuss how the dinner is going to take place, because it's sort of straightforward and there's nothing to discuss really. So that's why in a number of cases in Vietnam that I've sat on so far, there is no precision order number one. Party just, be surprised to hear of the concept in the first place. And cases that get sorted without such a thing. Well, yes, that might be true for many cases, but in many other cases, it may actually be counterproductive in the sense that things happen along the way. If the tribunal simply goes ahead and fixes a date of hearing, one of the parties might say, oh, I'm sorry, that day, I'm getting married, cannot do it. Didn't know. Then you're going to go back and forth, and you said another day. Then the next person says, oh, I'm sorry, that day I'm getting married now. Wow. What can you do? And in some other cases where I've sat on, one party turns up at the hearing with many more documents. Oh, I've just filed these yesterday. Right? So because there's no planning, things may go wrong. People may get surprised, and that would eventually make the entire thing inefficient because the German will need to follow. So my suggestion there is that the PO number one concept, practice, should be applied as a norm. Unless, of course, there are already exceptions to everything. And when it's clearly not required, then maybe that's fine. But as a norm, we should all consider having a plan before we do it. That's as simple as that. Point number two that I'd like to advocate is the cooperation amongst the parties. Now, this is where I've seen, this is a key point of difference between arbitration and court proceeding. As I said before, if you're in court proceeding, everything is decided by the judge. There's no room for party autonomy. There's no room for party cooperation. The judge conducts the proceeding and the parties follow, finished. So the parties, the lawyers, become often very passive, and they often sit back and wait for the decision of the judge, and they follow. They never get proactive and try to participate in the process. They never talk to the other party, right? In arbitration, it's different. If the parties talk together and cooperate, the parties together can have significant control over the proceeding and how it's conducted. For example, there might be, pick the hearing date as an example, right? If the parties don't cooperate and the tribunal fixes a date, one party says, oh, I'm busy. That takes a week, 2 weeks to set another date. Then the next party says, oh, I'm busy on that day. Where do we go now? Whereas what should be done, it could be very simple. The parties pick up the phone, talk to each other for 5 minutes. Together, they agree on a range of dates, and they submit to the tribunal, who will pick one of those. It takes 10 minutes, but with some cooperation, a hearing date can be fixed very easily to everybody's convenience. So the parties should cooperate in the process to narrow the disputed issues, avoiding the need for the tribunal to decide. If both parties agree that, for example, that only Article 4 of the law on arbitration needs to be translated, well, very often, the tribunal will just agree with that agreement, party autonomy. So what about in the Vietnam context? I would encourage the parties to cooperate and try to agree as much as possible. Procedural issues such as timetable that we discussed, logistics. Where are we going to hold the hearing? Or even sometimes payments. Who's to pay for what? We can decide, the tribunal will decide to allocate the cost later, but for the moment, can you pay for the dinner and I will pay for the lunch? And just proceed. Even for substantive issues, you can also agree. facts and chronology, what happened, and often there's not much disputed. Sometimes there are some disputed facts, but often majority of the facts are undisputed. Let's just agree on those. What are the list of issues to be decided? Let's just agree on those and leave it to the tribunal to decide. So you shouldn't be fighting over everything. However, what I've seen again is that in the Vietnam context, sometimes the parties, the lawyers, continue to act as if they were in a court. Very passive, just wait for a decision to be made for them by the court, by the tribunal. And somehow the parties or the lawyers assume that if they are in dispute, then they dispute. They would never talk to each other. Because if they talk to each other, that might be seen as being compromising. If you pick up the phone and call the other lawyer, it's like you're in a weaker position. And sometimes you even do the opposite, which is use unprofessional tactics to delay the process, to make it difficult for the other side. In some cases, that might be justified, but in a lot of cases, I think cooperation is better than no cooperation. Because one of the advantages of arbitration is party autonomy and efficiency. And it goes without saying that if you cooperate, things often get done more easily and more efficiently, as opposed to when you don't cooperate. Simple as that. So therefore, my suggestion on the second point is that parties, or at least the lawyers, should cooperate to make the full advantage of arbitration. Even when the parties are in a bitter dispute, the lawyers don't have to be. Right? You can still be the best of friends, because on this case, you might be opposing counsel. On the next case, you might even work together as co-counsel. Right? You just never know. And so here's the second part that I wanted to advocate today, which is that there should be a much higher degree of parties cooperation and therefore a higher degree of party autonomy in arbitral proceeding, which is an international norm that I've seen and should be applied here as well. Now, the final point that I'd like to get onto, and this applies mainly for the tribunal, but not to the parties, which is when to prepare the award. Now, what I've seen in lots of other jurisdictions, a very common practice is that the tribunal members prepare the award very early on. As soon as they get the materials in, they start writing the award. As for me, I always try to set out at least 2 weeks, assuming the case of average complexity, sort of after most of the submissions have come in. I mean, I read them along the way, but after I've got all the submissions in, I would set aside maybe 2 weeks to draft the award, even if I don't end up being the person drafting it in the end. Sometimes the chairman drafted it, but I do so for every of my case so that I get a full understanding of the issues. Unless I draft the award and write it out and just the way I operate. I mean, unless I write it out, I can't understand it. But the moment I've written everything down in front of me in a fully reasoned award, right to the end, it helps me focus on the key matters, understand the issues. So I know all of the issues already, and I can focus on those during the submission process and in the hearing. I can start talking to my fellow tribunal members before the hearing. I don't need to wait until after the hearing to talk to them. And if I come to the hearing with a full award, only with blanks to fill out, or a few question marks here and there, I can very quickly finalize it after the hearing because I can then fill out the details. I can ask the right questions. I can fill out the correct information, and then I've got it, maybe the day after. The last thing you want to happen as a tribunal member is that you only start preparing the award after the hearing, and then you think to yourself, oh my God, that particular point I forgot to ask in the hearing. What do I do now? The parties have gone home. Who do I ask? But unless I ask them, I can't resolve the case. So what do I do? And so I think that sort of thing should be avoided in my experience. Going back to the Vietnam context, again, for a lot of the cases, because the cases are simple and straightforward, the issues are straightforward. And some tribunal members may feel quite comfortable preparing the award after the hearing because there's only so much to write about. Some tribunal members even prefer to wait until the hearing to hear the
So I think that there's some technical difficulties at the Hope end. So I would like to take the chance to have Mr. Herb to introduce with all the guests of
prepare
our
the award as early as possible.
Now he's back. I'm sorry, Mr. Herb, you have just disconnected.
Oh, sorry. Okay, I'll go back and I just repeat this particular slide.
And please, after you finish your presentation, may I ask you a favor of introduce to all the guests about our panelists who are very experienced experts.
Yes, yes. Thank you, Ms. Han. So going back to the drafting of the award, the only part that I was trying to stress there is that the award should be prepared as early as possible to help the tribunal members understand the case fully. And as I said in the Vietnam context, I've seen some tribunal members prefer to hear the presentation by the parties first. Some other arbitrators prefer to discuss with the fellow tribunal members first. Otherwise, they think they are prejudging the issue. So my view is that the earlier you prepare it, the earlier you can issue it, and therefore the more efficient the proceeding will be. Again, no cases are 100% identical. What I've said before might apply very well in some cases and might not apply at all in some other cases. And that's the beauty of arbitration, that you can be flexible, right? Each case might require a bespoke solution, and you've got the flexibility to devise a tailor-made, customized solution to every problem. However, I think there are some general standard practices in international proceedings, and one at least should be aware of these practices, the differences, the reasons as when to apply what or not, because some might be applicable in Vietnam, some might be not, some might be applicable in this particular case, but not in the other case. But at the end of the day, you need to understand, be aware of these. There are differences because you might be dealing with tribunal members or counsel from various different jurisdictions. A good understanding of these practices will help you conduct the proceeding much more efficiently. So I won't leave it there. I mean, again, as I was saying, I could continue for the whole day, but we don't have the whole day. And we've got very exciting, interesting presentation to be delivered by our other panelists. So let's get on with those, and then we'll come back to the questions after that. The first speaker on the panel, I've got the great honor to introduce Ms. Minh from Dzungsrt and Associates. And Minh is a young but highly experienced practitioner in the area of international arbitration. She's now a partner, congratulations, with Dzungsrt and Associates. She was originally trained in Vietnam, and she was one of the best graduates of her class. Then she went on to study arbitration at University of Leicester in the UK. Now, she's very strong in shipping because the firm has got a very strong shipping practice, but she's also very experienced in arbitration. She has done a lot of cases at VIAC. She's done cases at the ICC, SIAC, SCMA. She has assisted with enforcement of foreign arbitral awards. And so she's done many things. And I think she's one of the few practitioners in Vietnam who's got such a wide range of experience. She's also a very keen
Okay, so I think that there's some difficult happen again at the Mr. Hope end. So I'd like to invite Ms. Minh to start with her presentation in order to save some time. Ms. Ha, please.
Good afternoon. Thank you, Mr. Herb and Ms. Hong, for giving me the floor. I would firstly spread my sincere thanks to VIAC for giving me this opportunity to sit in the panel with the senior experienced lawyers like Mr. Herb, Mr. Nate, and Mr. Edmund Kronenburg. And it is such a great honor for me. And I am also very happy to share my own experience with the audience here, who are students and young practitioners. And I hope that this webinar today will also give you the inspiration to study arbitration, research on this field, and start your career on arbitration like myself did more than 10 years ago when I attended the class of Dr. Herb in my undergraduate at the Diplomatic Academy of Vietnam. And now regarding my talk, I would like to focus on some feature of the arbitral proceeding in some foreign arbitration institutions, which I find that it would be helpful if it would be applied in the arbitral proceeding in Vietnam. I have 4 key points in my talks, as you can see in the slideshow. Firstly, regarding the notice of arbitration, request for arbitration and the answer. And we Vietnamese arbitration practitioner, we are very familiar with the concept of request for arbitration, which is used in the English version of the VIAC rules. And to be concise, this concept is also included in the law on commercial arbitration of Vietnam. And actually, this terms to be translated in Vietnam as in English as a statement of claim. And it actually serves as a statement of claim as it requires the claimant to specify in details the basic and legal ground for their claims. And in Vietnam, the arbitration proceeding normally starts with the request for arbitration. And in response to the request for arbitration, the respondent must submit the statement of defense. And they also have to include the legal backgrounds for their defense in that document. However, in international arbitration, the arbitration proceeding usually starts with the notice of arbitration. And this document is very much like just a notice in which the claimants only brief the dispute, and they do not require to stating the legal ground for their claims in this document. In response to the notice of arbitration, the respondent also submit the document named the answer. As you can see in the slide, it appears in the rules of many foreign international arbitration institutions such as SIAC, KCAB, and HKIAC. And the claimant and the respondent shall then at later stage have other opportunities to specify the legal grounds in the actual statement of claim and statement of defense. In my personal opinion and based on my experience, the proceeding starting with the notice of arbitration and answer would be much easier for both the claimant and respondent, as they do not have to prepare too much in these initial steps. However, I understand that the VIAC rules must be in compliance with the law on commercial arbitration, which is much affected by the litigation proceedings, where the proceeding commenced also by the statement of claim. Secondly, I would like to share about the application of the soft law in the international arbitral proceeding. That is the difference which I see in the international arbitration in comparison to the VIAC arbitration. For your ease of understanding, soft law is often a set of rules recommended by famous international professional organizations such as the International Bar Association, frequently known as the IBA. And one of the most frequently used rules of the IBA is either IBA rules on taking of evidence, which provide the detailed guidance on the process of document production, the admissibility of evidence, preparation of witness statement, and evidentiary hearing. As you can see in my slide, these rules are very frequently used in the international arbitration. However, though there has not been any statistics on the application of these rules in VIAC, in my experience, not many VIAC cases expressly recognize the application of the soft law in general and the IBA rules on taking of evidence in particular. And one of the reasons for that is that in order to be applied, the application must be consent by the parties. Meanwhile, the Vietnamese parties are not familiar with these rules and usually hesitate to apply it. And even if the rules are applied without the consent of the parties, the awards will face with a risk of being annulled by the court. And I think that if these rules are applied in the arbitral proceeding in Vietnam, it will play helpful roles in supplementing the hard law, as because instead of having to decide by themselves on the procedure of documents production, the admissibility of evidence, preparation of witness, and many other factors, the arbitral tribunal can only refer to the application of the rules, which would be more time and cost efficiency. Moving to the next point, regarding the eventual hearing, as mentioned by Dr. Herb before, under Vietnamese side, the parties usually leave it to the arbitral tribunal to do all the things with the case, and even in the conducting of the hearing. Generally, in international arbitration, the eventual hearings mainly focus on the cross-examination, which is usually led by the counsels of the party instead of the arbitral tribunal. The arbitral tribunal will only pose additional questions where they find it necessary to do so. Meanwhile, in VIAC hearing, the cross-examination of witness, if any, is usually led by the arbitral tribunal. And furthermore, in my experience, there is not any compulsory requirements on the preparation and submission of the witness statement before the hearing. And in many cases that I deal with, the counsels are very passive as the witness suddenly appear and without any prior inform to the arbitral tribunal and even without the notice of their attendance. And in some other case, the witness only submit their witness statement but do not appear in the hearing. And then the counsels have no opportunity to cross-examine the witnesses on what they stated in their statement. And I think that the hearing would be much efficient if the rules on witness would be applied and agreed by the tribunal and the parties before the hearing. And finally, I would touch on my last point regarding the publishment of the practice note. I think that it is not a procedural matter, but it is helpful tool which would increase the efficiency of the arbitral proceeding as well as the outcome of the arbitration. In the international arbitration institutions such as ICC, SIAC, they usually issue their practice notes, which usually explain the practical matters that the parties may face with when they following their arbitration rules. And these notes would help the arbitral tribunal to reach a consistency in interpreting and applying the rules of such institutions. And furthermore, some international arbitration institutions also summarize some precedents regarding procedural matters, like how certain procedural matters have been dealing with by the previous tribunals, in order to guide the arbitral tribunal to deal with the particular issues. And on this regard, I note that VIAC also published books on VIAC awards addressing substantive issues which are usually resolved by VIAC. And in many cases, the arbitral tribunal may consult with the VIAC on how some particular matters regarding procedural matters are resolved by the arbitral tribunals. However, for the consistency of the application, I think that it would be much helpful if practice notes on procedural matters are also published for the ease of application, not only for the parties, but also for the arbitral tribunal. And in conclusion, I have been asked to share my best experience in conducting the arbitral proceeding in international arbitration, but so far I have not found any practice that would be best. But I think that I can have point out some differences in the proceeding of foreign arbitration and in comparison to the VIAC arbitration. And I think that if the good points can be adopted in the arbitral proceeding in Vietnam, it would increase the effective efficiency of the current proceeding in VIAC. Thank you for listening to me, and now I give the floor back to Mr. Moderator. Thank you.
Thank you, Ha. That was most enlightening and helpful. I'm sure the audience will have a lot of questions arising from the presentation a bit later. But now, let's continue with the presentation from another speaker, Dr. Net, who probably requires no introduction because he's very well known in the arbitration circle. I've had the privilege of knowing Mr. Net for a long time, both as a colleague and as a friend. And in fact, I've sat with him on several tribunals. And indeed, I think I might have sat with him on my first case ever, many, many years ago. And I've had the privilege of working with him both on the profession as well as on the other social and community matters. He was trained originally in Warsaw. He went on to did his master's in Leuven and then his PhD at LSE. He's been the managing partner of LNT, as many of you already know. He's on the panel of arbitrator of the VIAC and the SIAC. He's done a lot of cases, both as counsel and as arbitrator, so he's got a ton of experience to share with you. I think I can go on for another day with his introduction, but I'll leave it there, and I give the floor to Mr. Net. Thank you very much.
Thank you very much, anh Hợp, for your introduction. It's flattered me a lot. I'm not the managing partner. The managing partner is Xuan, my colleague. I'm very honored to know Mr. Hợp, Dr. Hợp, and many other colleagues at the BBLC. We are proud to contribute to GES scholarship that is happening for more than 10 years now, right? Anh Hợp, that produce a lot of rising stars lawyers and also rising star officials in ministries. that protect the interests of our country, and also to protect the interests of the client, and also contribute positively to the growth of legal community. And to that, we have to give first credit to Dr. Hup, and we really admire Dr. Hup for contribution to society, as well as you know, for arbitration. So may I share a little bit of my what I learned from being arbitrators or counsel to arbitration. From my perspective as the arbitrator in VIAC arbitration rule, and also the counsel in some of the international arbitration proceedings. So to do that, I would like to share my presentation, and it won't take a long time from you. I hope you can see it. So now this is a best practice in arbitration, Vietnam. So what I would like to present, discuss is about the purpose of arbitration and the basic principles of arbitration and mistakes, and the basic principle of Vietnam law. I use the word basic principle because it is a famous word that is used in Article 68. And it is my personal view. What is the basic principle? It's not the general view of the court or the law, because right now we still don't have the official view of what is the basic principles. So the purpose of the purpose of arbitration is to solve the dispute fairly in accordance with law and natural justice. When it talking about fair, is difficult to say, because fair or not fair really depend on what the parties present. If they think they have a case, but they cannot show to the arbitrators that their case it would be fair to have them win the case, then it's tough luck, I think. So to achieve fairness is the goal of all the parties, including the arbitrators. But whether to achieve that, it needs cooperation, like Dr. Hup said, from the parties. And the arbitrator is only as fair as the parties can present to the arbitrators, in accordance with law, of course, because that is the framework where we work with, and in natural justice, because we want the case to be predictable. We want arbitration to be predictable. We don't want surprise when going to arbitration. And we want arbitration to come out with the result better than court, because like it or not, we are competing with the court in winning the trust from business community. So we have to give what the parties, claimants or respondent alike, how do they expect? If they breach the contract, they have to pay. If they don't breach the contract, they don't have to pay. If both parties breach the contract, then they pay according to their fault, the degree of the fault. So this is what we want to achieve. That's number one. Number two, I think we want to have a robust award and avoiding to be set aside, because we all know that there could be the court without arbitration, but there is no arbitration without court anywhere in the world. So the court will supervise. If you are in Singapore, there will be a Singapore court to supervise. You are in England, you have English court to supervise. You are in Vietnam, you have Vietnamese court to supervise. So we should be aware of that. And because of that, we want the award to be fair and accordance with law and with natural justice. Now,
Dr. Ned, sorry, can you move the slide? Can you move the slide?
Yeah, because a little further. So procedural robust means in accordance with the principle, I think, set forth under Article 4 of the Commercial Arbitration Law. And substantive robust is the content does not violate general principle of Vietnam law. Now, that's the word that they use, and they use the word content. That means what they say that or sorry, what the law say that the court shall not look at the content of the dispute. It has the limit. If the content violates general principle of Vietnam law, they might. So how to avoid that? So for example, come to the first, it's about the general principle arbitration law procedural. There is Article 4. So the first paragraph 1 of Article 4 is arbitrators must respect the parties' agreement if such agreements neither breach prohibition nor contravene the social ethics. So the possible mistakes or violation is that the tribunal gave award on issue nobody asked, and that would give the parties a surprise. Or the tribunal misinterpret or disregard the agreement between the parties, or the tribunal disregard the pre-arbitration process. So let's say if they say that you have to go through the notice of disagreement with the engineer determination, and you miss that, or you have to go to DAB and you miss that, that means you do not respect the parties' agreement. Now, to that aspect, you have to also credit the who breached the parties' agreement, because some parties don't cooperate, they don't appoint the DAB. So that was the other party who breached the parties' agreement first, not the claimant. And we have to remember there's a provision in the civil law say that in the conditional transaction, if a condition is not achieved because of one of the party, then that condition is deemed to be achieved. So we have to refer to that to say that, yeah, we respect the parties' agreement, but in this case, we deem that agreement to be achieved. That's point number 1. Point number 2, arbitration must be independent, objective, and impartial, and shall observe the law. So the common mistakes to that is the parties, the arbitrators are related to lawyers of the parties, or arbitrators are close friends or tight arbitrators. So like if you look at the history, there's one arbitrator and the other arbitrator, they always go hand in hand. That is something that could be suspicious on independence, objective, and impartial. Or they observe, or they don't observe the law. That might be the situation of a possible mistake or violation. Point number 3.
Dr. Ned, the slides are not moving on the screen. Can you move it, or I'll leave it to you?
Is that now on the general principle arbitration law, part 2?
No, it's still on the first slide. It's still on the first slide.
Dr. Nate, can I let us share the screen instead of you, sir?
Okay. If that can help.
Yes.
Thank you so much. So I am now on screen number 3. Next slide, please. And next slide, please. So the next point is that disputing parties are equal in their rights and obligations. The arbitration council or tribunal shall create conditions for disputing parties to exercise their rights and fulfill their obligation. So if the mistakes and errors is that there might be lack of procedural ordinable one. So people are confused when they should submit the submission and when they should submit the witness statement, when they should submit the expert. And it comes to the situation that one party disclose everything, the other party hold on information, and that create an inequality in access to information between the parties. Or the tribunal is too anxious to give decision without asking one of the parties. So they just start shoot from the hip. When they receive a request from one party, they make a decision immediately without asking the other parties, what do you think about that? And in so doing, they don't give the parties equal rights to be heard. Now, VIAC arbitration is different from other arbitrations in the sense that you have all the advance money, the arbitration fee coming from the claimant. In other case, in other arbitration proceeding, each of the parties share 50% of the advance of the arbitration fee. So the equality starts right there. But in VIAC, the arbitrator have to be very, very careful and also not breaching the principle of equality between the parties. The tribunal unreasonably reject requests of the party or disregard evidence presented by one of the party that might have a concern on the disputing party are equal in their rights and obligation. So those could be considered a serious breach to principle number 3, paragraph 3 of Article 4. And number 5 is that arbitral awards are final. So if the case is res judicata and one of the parties submit, res judicata means the case already decided in another award or another court decision, and then one of the parties submit arbitration to rehearse about the case, then that would be, the tribunal would violate res judicata principle if they do not regard the principle that the other arbitral awards is already final, or if the tribunal can make another decision inconsistent with a previous decision upon request of the explanation of the parties. So that could be a problem of the arbitral award final principle. They are own general principle. Can we turn on to the next slide, please? Now it comes to the substantive law. What are the general principles? To me, the general principle of substantive law is in Article 3 of the Civil Code. So number 1 is that every person has the equal rights in civil relation and may not use any reason of unequal treatment to others. So it's similar to Article 4, paragraph 1 of commercial arbitration law, which should treat the parties equally. Number 3, each person established, exercise, or fulfills, terminates their right on the basis of freely and voluntary entering into commitment. So that is also similar to the paragraph 1 of the Article 4 of commercial arbitration law, is to respect the agreement between the parties. So therefore, disregard the agreement that prove correct interpretation of the agreement may amount to the award being set aside. Now, the difficulties of the tribunal is not on regarding or disregarding the agreement of party, as long as it is clear. But most of the time, the people dispute about unclear parts. And now it comes to the situation of interpretation of the agreement. And there you have to refer to Article 409 of the Civil Code on the principle of interpretation. It really also depends upon the purpose of interpretation in civil law, which is reach out to the intention of the parties, or the purpose interpretation under common law, which is reach out to the reasonable meaning of the contract, which is objective interpretation vis-a-vis subjective interpretation. That is where not only the applicable law that makes sense, but also the background of the arbitrators that makes sense. So even common law background arbitrators who read Vietnamese law, he or she might have problem interpreting what is the real intention of the parties. And similarly, people from civil law, if they apply English law, he or she might have a problem of interpreting what is the reasonable meaning of the clause. So those are the things that we might need to pay attention to. Can we move to the next slide? And then paragraph 3, I think, is less likely to be a reason to be set aside with it in principle, goodwill and honesty. Because the words of goodwill and honesty is also difficult to prove, but never and cannot be a reason how to set aside the award. At least I don't see that it's the reason to set aside so far. Number 4, the establishment, exercise, and termination of civil rights and obligation might not infringe national interest, public interest, lawful rights, and the interests of the other parties. And when I see the court handbook about dealing with the arbitral award, it could be the most likely reason to setting aside. So when principle clashes, public interest would prevail against private interest. I think it's also that's the principle under common law as well. But it is more likely than not if the award impact not only the interests of the parties, but also the interests of a third party, but and more importantly, it could be the public interest as well. Then it comes to the situation that number 5 is less likely reason. So I would like to omit that. So come to the next slide. Yeah, could you turn on the next slide, please? So the lessons, I think what I learned is that I should be aware of trap that make the award being set aside. I should be fair to both parties, give them equal rights. I would be independent and withdraw from if I cannot independent or impartial. And maybe others, the experience that I learned from. Unfortunately, we are operating in the system that is quite new in arbitration, and we always have to be aware of how we come up with in the award. So those are the things that, from my personal view, we might need to pay attention to. So thank you very much, Dr. Hop, for giving me the opportunity to share.
Thank you, Dr. Net. That was very, very insightful. And one of the audience members just commented on the chat section that he always enjoys hearing your presentation in every conference. And so very, very well said. Thank you. Next on the panel, we're very lucky to have a speaker from Singapore, Mr. Edmund Kronenburg. And I'm very proud to say that we've known him as a colleague, but also as a very good friend of Vietnam in general and Vietnam Arbitration Circle in particular. I've had the privilege of speaking with him on conferences, as well as actually having him as a chairman of one of the tribunals that I've been on at the moment at the VIAC. Edmund is the managing partner of Braddell in Singapore. I think the second oldest independent law practice in Singapore, Braddell Brothers. And he has a lot of experience in litigation and arbitration. He has done a lot of cases in various sectors, and he sits as arbitrators in various institutions, and he has conducted cases as counsel also in these jurisdictions. Coming from Singapore is a very established and developed jurisdiction in terms of arbitration, as we all know. I'm sure Edmund will have a lot to share with us on the international practice and whether they may be adapted in Vietnam. And thank you so much for taking the time, Edmund, and the floor is yours. Thank you very much.
Thank you very much, Dr. Hop. I'm very, very pleased to be here, and I'm very grateful to VIAC for asking me to speak at this webinar. I hope that my presentation will be interesting for all of you. Let me put it on screen right now. I need to bring it across. Whoops, sorry. And I need to bring it across. Just give me a second.
I'm not sure whether you saw it on the chat section, but one of the audience members asked about your experience in cross-examination in Singapore. So there you go.
Yes, I'll definitely be considering that. I'm having a slight problem with the slides, but don't worry, I can handle it. Just give me a second. And I just need to bring the presentation across to the front screen because I'm using two. I'm not sure if you can see my screen right now. Hang on a minute.
No, not yet.
All right, I'm handling that right now. And I hit share. And you should be able to see my screen right now. Dr. Hop, can you see it?
Yes.
Great.
Yes.
Thank you very much.
Yes.
Okay. So I'm going to be speaking about some useful common practices in international arbitration. I'm going to be dealing with only three because of the limited time available. The first is witness statements. The second is about cross-examination of witnesses. And the third deals with document production. So let's talk about witness statements. Now, you've heard Ms. Ha mention witness statements before. A lot of people have said, oh, we've heard this term, but what exactly do witness statements contain? What are witness statements? Well, you know, when a witness comes to testify in an arbitration, the witness gives his evidence, gives his name, answers questions from the lawyers, but the witness statement cuts all that out and shortens this process, because what happens is in the witness statement, the evidence of the witness is written down in prose form. Now that means not in question and answer format, but in the form of a story with numbered paragraphs. I'm going to show you an example of this, and it is then signed off by the witness as being true and correct. If there are any documents that the witness is referring to, often the witness will annex these documents to the back of the witness statement. See Exhibit 1, see Exhibit 2, see Exhibit 3, etc. So that when you're reading the witness statement, you can flip to the back of the witness statement and see the actual document that the witness is referring to. The witness then comes to the hearing and he confirms the truth and accuracy of the witness statement to the tribunal. So he must attend the hearing. He can't just put in a witness statement. He comes to the hearing and he says, this is my witness statement, that's my name, that's my signature. The contents of this witness statement are true and correct. Then he will be cross-examined on the witness statement. The tribunal can also ask him questions. This removes the need for the lawyers to ask the witness, what is your name? What is your address? Do you know about the dispute in this case? Do you know the claimant? Do you know the respondent? What is your evidence? Where were you on this particular day? The lawyer doesn't have to do any of that. The tribunal doesn't have to do any of that. It's all written down. So it saves a lot of time. And this is a common feature of international arbitration. It is very rare, almost non-existent, to find an international arbitration in, let's say, Singapore or New York or London or Paris that does not use witness statements. The reason why witness statements have become so popular, or a major reason, is because of something called the IBA rules on the taking of evidence in international arbitration. Now, Ms. Ha has already mentioned this. Witness statements are dealt with in Article 4 of this soft law. And that's a URL, that's a code there that will bring you to the IBA rules. If you need a copy of these slides, please ask VIAC. They will give you a copy of the slides. The witness statements are very useful in placing the witness's evidence before the tribunal quickly, clearly, and effectively, because it's all clearly written down with numbers. So the tribunal can ask the witness, please look at paragraph 4. You said this. Could you explain this a little more? Or are you sure about this? Because I have this other document that says you were somewhere else on this day. So the tribunal can refer to the witness's evidence as already written down, and the tribunal can ask questions, and the lawyers can ask questions. It also allows, therefore, the cross-examination of the witness to be more structured. And I'll show you an example of this in just a moment. The downside to a witness statement, everything has a downside. You'll never find something which is perfect, which only has benefits but no disadvantages. So the disadvantage of a witness statement is that the witness statement is drafted usually by the lawyers on hearing what the witness's evidence is. Now, that doesn't mean that the lawyers can create evidence. It doesn't mean that the lawyers think up the evidence and say to the witness, you must say this. That would be wrong. The lawyers sit down with the witness, listen to the evidence of the witness, and write it down in an understandable form in the witness statement, right? The downside, however, is that the lawyers sometimes do too good a job. So sometimes it is not really believable that this is really the evidence of the witness. He doesn't speak this well. He doesn't use words like this. He's not so organized. The tribunal, therefore, has to determine how much of their witness statement it can actually rely on. Very often you can rely on most of the witness statement, but sometimes the witness statement is too good to be true. The tribunal has to figure this out. Here's an example of what could be said in a witness statement. All these names are fictitious. Please, any sort of similarity to real life is unintentional. So let's say this is a witness made on behalf of the respondent. in an arbitration by the witness Raka Nguyen. So he states his name, he states his address, and then he gives his evidence. He says, I'm a singer, actor, and celebrity. Paragraph 2, in 2017, I acted in a movie titled 100 Pounds Beauty, or in Vietnamese, I won't try and pronounce that, playing the role of Doi Kang. The role was very exciting. The director of the movie was Dzungsrt. One of my co-actors was Minh Dang, playing the role of Ha Minh. I now understand that there's a dispute between Minh Dang and Dzungsrt in relation to the proper amount to be paid to Minh Dang, based on how well the movie performed at the box office. Then he says, to my knowledge, there was no agreement at all between these persons that Minh Dang would be paid a bonus if the movie earned more than 2 trillion Vietnamese dong. So he states his evidence, and he carries on stating his evidence, and he signs off right at the end that the statement is true and correct. So you can see with this, it saves a lot of time. You can refer directly to the paragraph that you're looking at and ask questions based on that paragraph. We now get into the cross-examination of witnesses. This is a common feature of arbitration in common law countries like England, the US, and Singapore. But it is also a very common feature nowadays in arbitrations conducted in civil law countries as well. As you know, civil law countries have an inquisitorial process. In other words, the tribunal, the court, usually is the one asking the questions, not the lawyers. But even then, because of the IBA rules, in particular Article 8 of the IBA rules, this soft law, even in civil law countries, cross-examination has become very popular in arbitration. From experience, from the cross-examination that I've seen, this is quite infrequently done in VIAC arbitrations, if at all. And if it's done, it's not really done well. Now, I think this is owing to a lack of training. So if Vietnamese practitioners want to play on an international stage against English lawyers and US lawyers, they need to be trained in cross-examination. When do Singapore law students get trained in cross-examination? Law students in Singapore undergo 4 years of study. They get trained in cross-examination in year 2, in the second year. So as early as the second year, Singapore law students are trained to ask the right questions in cross-examination. And I think if you're doing international arbitration and you don't know how to cross-examine, you're at a severe disadvantage. So if you'd like to learn how to cross-examine, please drop me a line. The cross-examination is aimed at testing the evidence of a witness. Can you trust this witness? It's aimed at showing the tribunal that some parts of the witness's testimony might not be trustworthy. Cross-examination usually involves the use of asking what we call leading questions, yes-no questions, questions that suggest an answer. So for example, how, what, when, who, why, where. These are all open questions, open-ended questions. A leading question would be, is that wood? Is that a book? Are you the author of that paper? Is your name Dr. Hop? Those are examples of leading questions. Those leading questions are very useful in helping the tribunal ascertain the true facts of the case without sounding biased. Imagine a tribunal asking those leading questions of the witness. The witness might get the impression that the tribunal does not trust him and has already formed an impression about the witness. And then the side that calls that witness might get the impression that the tribunal has already decided it does not trust the respondent or the claimant, whichever side it's on. But if the lawyers ask the questions and the tribunal just sits back and listens, then the tribunal appears unbiased, which is good for the tribunal, and the lawyers take the role of testing the evidence as opposed to the tribunal. The lawyers ask the questions. Now, if this process is done correctly, the lawyer will use logical and clear phrasing of the questions. The construction of the questions will be very clear. Usually, there will be leading questions to be answered with a yes or a no. And each block of questions is usually strategically sequenced. So there's a good sequence that you can adopt to get to the eventual answer that you are trying to get out of the witness. What do I mean by all of this? I'm going to show you an example. So, for example, in that case where, we're talking about Rakang Yun, let's say Mr. Nga, the director, is being asked these questions. The lawyer says, Mr. Nga, could you please refer to your witness statement at paragraph 6? Here you testify you never made any promise to Minh Dang to pay a bonus if the movie performed well financially. Were you telling the truth there? And the witness then says, yes, that is the truth. Then the lawyer says, now you refer to the hearing bundle. Mr. Nga, pick up the hearing bundle. Please read the email you sent to Minh Dang on 15th October at page 152 of the hearing bundle. So the witness flips to page 152. The tribunal flips to page 152, and they see this email, 15th of October, and then the lawyer says, do you see the second paragraph where it says, and this is what Mr. Nga is writing, I assure you that you will receive a bonus should our movie do well, no less than 1 billion Vietnam dong. And then the lawyer asks the question, were you being honest with Minh Dang when you said this in your email? And the witness has to say yes, because if not, he says, oh, I was lying to Minh Dang, and he doesn't want to be known as a liar. So he will say yes. Right. Then the lawyer says, oh, sorry, too fast. Let's go back. Based on this, you had indeed promised Minh Dang to pay a bonus if the movie performed well financially. Do you agree? And the witness has to say, looking at the email, yes. So, Mr. Nga, based on your last answer, would you agree that the evidence you gave at paragraph 6 of your witness statement is not true? Do you wish to change it? And the witness is caught. So the witness will have to say, yes, I'm sorry, I wish to change it. So this is an example of how a cross-examination can test what the witness says in his direct evidence in the witness statement. The third point that I'd like to speak about is document production. Again, you've heard about this from Ms. Ha just now, but this is a bit more of an elaboration. So we know in an arbitration, a party may produce and rely on documents useful to its own case without producing any documents that are bad for it, any documents adverse to its case. But what if the other party has documents adverse to its case that the tribunal ought to see in order to make a just and fair decision, but those documents have not been produced to the tribunal? What then? So that's why we have document production. So document production allows you, a party, to ask for such documents, but you have to identify what those documents are and state why these documents are relevant and material to the outcome of the case. That comes from the IBA rules on the taking of evidence, Article 3. The sequence is this. You make a request to the other side to produce the document. There's this contract dated the 15th of October. Could you please produce the document? And this request is normally done in the form of what we call a red fern schedule. It's a table that you send to the other side. I'll show you this in just a moment. If the opposing party agrees to produce the document, he then produces the document voluntarily. He sends the document to the other side and the tribunal. If the opposing party refuses, for example, because there's no such document, the document doesn't exist, or because it is irrelevant or not material, the tribunal decides whether it should be produced. The tribunal thinks about this, and if the tribunal agrees that the document should be produced because the tribunal thinks it wants to see the document, then the tribunal makes an order that the party produce that document by a certain deadline. Now, this is entirely compatible, by the way, with VIAC Rules Article 19.2, where it says the tribunal shall have the power, at the request of a party or the parties, to request witnesses to provide information and documents relevant to the dispute. I spoke about a red fern schedule where you make the request. Let me show you a real red fern schedule from a real arbitration. And this comes from the internet. The source of this is stated at the bottom here. But if you look here, this is where the requests are made. So there's request number 1, request number 2, and it says under request 1, all financial statements audited or unaudited from April 2015 to the present, etc. So that is the class of documents that this requesting party, here the government of Canada in this case, the respondent, was asking for. And then the requesting party states the relevance and materiality and makes references to the earlier submissions, the statement of defense or statement of case by the parties. And all these little marks you see here are the paragraph marks. So they set out notice of arbitration, paragraphs 10 to 11, etc. And then they explain the reasons for the request. And then here, the other side can state why it's objecting, if it's objecting. The party requesting can state its reply, and then under decision is where the tribunal states its decision whether to order the production of the document. So this is a common feature, yet another common feature of international arbitration. So some concluding thoughts. I'd ask everybody listening to this to please consider the use of one or more of these common practices from international arbitration in your next VIAC arbitration. They are entirely compatible with VIAC arbitration, but you should get the parties and the tribunal all to agree to use these mechanisms. They save a lot of time and costs. Witness statements save a lot of time. Cross-examination reveals the truth to the tribunal without the tribunal getting into the fight and possibly appearing biased. And document production allows all the relevant material, that even material that's adverse to one side, to be shown to the tribunal so the tribunal can come to a fair and just decision. And I've just put there on the screen the IBA rules for the taking of evidence in international arbitration, which are very, very useful to be used, and they can be used in VIAC arbitrations if the parties agree and the tribunal agrees. The QR code, if you scan it, will bring you to the site where you can download these IBA rules. So with that, I end my presentation. Thank you very much for listening, and I'm stopping the screen share right now.
Thank you so much, Edmund. That was extremely insightful. I have learned quite a bit myself, taken a lot of notes here, and I'm sure so has the audience. And I think very useful that you suggested that if anyone's got a question about cross-examination, that you'll be the person to come to. And so careful when you wish for. Your email, your inbox might have been already inundated with emails and questions. Thank you so much for that. We'll return to Edmund with some further questions for the Q&A session. But to continue with the panel discussion, we'll hear next, last but not least, from Ms. Hung at the VIAC, who has been currently organizing this webinar. And the VIAC, as you know, has been doing a lot of these training activities to promote arbitration and try to make arbitration better and better day by day in Vietnam. So we owe a lot to the VIAC for doing this great job. Hung has been a member of the secretariat of the VIAC for a long time, and I've had her in a number of my cases when she was acting as counsel before she moved on to taking charge of the other, probably more important task at the VIAC. And so she's now been one of the key persons running these very useful activities from the VIAC. I would be very interested to hear from her on the VIAC's perspective on how arbitration in Vietnam is being conducted and how international practices might be adapted in Vietnam. So can I pass the floor to Ms. Hung? Thank you very much.
Thank you so much, Anh Hợp. You have given me so many kind words. Yes, and firstly, I'd like to thank you to all the other panelists who have just gave a lot of information about the practice, the arbitration practice that they have experienced. And as a member of the Secretariat, I'd like to have a very short sharings on, in complementary to other speakers' information. And before that, I'd like to have a very brief, brief about the legal framework on arbitration in Vietnam. As you know that we have a law on commercial arbitration 2010, and before that we have the ordinance. But I believe that the law on commercial arbitration 2010 is considered to be adopted the fundamental principles of the ancestral model law on arbitration. And those we still have a few discrepancy with the model law, but I understand that the law on commercial arbitration has set a very good and very advantageous environment for the arbitration to develop in Vietnam. And then we have the resolution from the Supreme Court in 2014 to guide all the judges about how to interpret and how to support and how to supervise the arbitration in Vietnam. So thanks to that, I have to say thanks to all those developments, the arbitration in Vietnam has made a very impressive developments in 2013, and you can see that our caseload at Vietnam International Arbitration Centre has made a very good rise since then. So I'd like to make a very brief comment about the arbitration proceedings at VIAC. As you might already know about our rules of arbitration, you can see that the proceeding following the regulation strictly follow the regulation of the law on commercial arbitration as the curial law for all the arbitration proceedings that's seated in Vietnam. And but at the same time, as an international arbitration center, VIAC is still trying to adopt all the international standards procedure. For example, like the witness statement, witness cross-examination that Ms. Ha or Mr. Edmund have just presented. However, the majority, I have to emphasize that the majority of the enterprises in Vietnam are the small and medium size. So the arbitration case at VIAC is relatively small in comparison with their counterpart in foreign arbitration institution. And recently, in about 3 or 5 years, we have received we started to receive bigger cases involve the huge amount of money, around 100 200 million US dollar cases, and that's the moment that from that time VIAC has made a very quick change in our practice in order to ensure that for those cases, all the standards international arbitration procedure could be conducted and took place in Vietnam conveniently. So the second matter is about the arbitrators. As you can see that we are now maintaining a list of arbitrators who are very well-known experts in so many industry in Vietnam, and at the same time, we are maybe the only arbitration institution in Vietnam having foreign arbitrators on our panel, and also for the cases with the international related to international matters, the parties are free to choose any expert. Either they are Vietnamese or foreigner, they can be seated at arbitration at VIAC, conveniently without any further requirements. So I think that with that type of approach, we are now very open to adopt the international ways of procedures. With that approach, I believe that the proceeding at VIAC could be at the same time to serve the domestic cases with small amount of money involved, with the small and medium-sized enterprises involved. And at the same time, we can still provide good services for the international cases with a huge money in dispute, huge amount of money is in dispute. And the other things that I would like to emphasize is that at VIAC, we believe that in a young jurisdiction like Vietnam, there might be, a lot of circumstances when the legal regulation are not so clear, or the interpretation of the legal provision are not so secure or so clear. So that's why we have a secretariat who consisting of a very dedicated counsel who are very well experienced with the arbitration proceeding in Vietnam, who could at the same time provide the administrative support to the arbitration, to the arbitrator conducted arbitration at VIAC. And at the same time, we can provide the tribunal with the best information about the practice in Vietnam for them to, make a very comprehensive and well-informed decision during their, conducting arbitration at VIAC. So so maybe that is the last thing I would like to emphasize, that we always strictly follow the principle of respecting the independence of the arbitral tribunals who conducting arbitration at VIAC. But at the same time, we have a very good and very dedicated counsel assisting the tribunals with all the information about our practice. So I believe that might be the way how VIAC could still try to adapt at the same time for the domestic market and for the international, cases. Thank you so much.
Thank you, Han, for your very insightful comments from the VIAC's perspective. I'm sure the VIAC will continue to do a lot more for the community, like the current webinar. Now, I think probably thank you for your patience in continuing to listen to the presentation so far. I think now comes the most exciting part, where we interact with the audience through the questions that you have put up on the Q&A section. The first question that I've seen here in my chat box is one about how to become an arbitrator in Vietnam or internationally. Probably, can I just pick on both Dr. Ned and then Mr. Edmund Kronenburg for two different perspectives. Can I ask Dr. Ned first on how to become an arbitrator in Vietnam, and then we'll ask Edmund to speak on Singapore. How did you end up being an arbitrator, and what was the process? What happened? Can you share with us?
Okay, I was invited to become a panelist arbitrator in 2007, and I don't know how. And I was invited by Mr. Chi. He passed away already, and about 5 or 6 years later, when I met with Mr. Huỳnh, he said that was him who suggested me on the list. And the reason is because I wrote books and make a lot of comments about contracts, and I teach contract law, and I'm a lawyer in international law firm and then local law firm. So that's why he positively invite me there. So, but I also received a request from my colleagues say that could you recommend me to become an arbitrator of VIAC, which I say yes, but it's not up to me. And some of my recommendations successful, some not. So it's really up to VIAC to accept anyone to become a panelist. For SIAC, I think I initiate myself to become a panelist, and SIAC report to me that you need to give experience, a credential on being arbitrators, and I submit my credential to SIAC, and then SIAC accept me as such. So that's it's my experience. Thank you.
Thank you, Doctor. I think as they say in English, sometimes your fame precedes you. If you're famous, things just come to you unexpectedly. But I think we've got some good advice there. You know, you've got to be writing articles, writing books, you've got to be publishing, you've got to have a lot of experience as counsel, as an arbitrator. So I think a combination of both legal practice, experience, and probably academic publication might help there from Dr. Ned. Thank you. Can we turn to Edmund from your perspective? How did it happen to you?
Thanks, Hop. Well, you know, I've been doing disputes for about 23 years now, and I started out with some arbitration cases. But I think, you know, to become an arbitrator, moving from counsel to arbitrator it's a bit of a jump. And what was really, really useful was attending courses and passing exams with the Chartered Institute of Arbitrators. Or in Singapore, we also have the Singapore Institute of Arbitrators. So any of these institutes would run official courses where they teach you about the law and international arbitration, arbitration procedure, and you pick up a lot of things there. And you also make a very good network of friends who, you know, you can learn from and interact with and exchange ideas with in international arbitration. And from there, because of their network, they might find themselves in a situation where they are a party-appointed arbitrator, and then they need a chair, or you may find yourself a party-appointed arbitrator, and you need to find a chairman, a presiding arbitrator, and because of their network, and we know one another, and we know who you can rely on to be a good presiding arbitrator. As a result of that, you get arbitral appointments. So the first step is basically learning about arbitration, getting your credentials from, say, the Chartered Institute, Singapore Institute, whatever institutes you have in Vietnam officially teaching arbitration, and then you move on to actually getting appointments, which will come.
Thank you. I mean, that was very, very useful. So apart from legal experience, practical experience and publication mentioned by Dr. Ned, now you've got you need to have qualifications as an arbitrator. You know, you go to the institute and get the training, get the certificates, and importantly, you've got to have your network, because even if you've got experience, qualification, and paper, but you know no one knows you, well, you're not going to get anywhere. And so it's very important to have network. And from my own experience, I think it took me 10 years to get my first case. So from the moment when I thought I want to be an arbitrator, it took me 10 years to get my first appointment. So it was quite a bit of a process. Others may take shorter, I don't know, but for me it was 10 years. Thank you so much for that. Now we move on to the next question. I saw here, where is it gone? There was a question for Dr. Ned specifically. Here, the question here, I used to sit in many conferences that Mr. Ned delivered. I always find your speech so useful. In your experience, if you're advising a Vietnamese company in an international transaction IT industry, how do you draft the arbitration clause to be most efficient? Thank you. Dr. Ned, can you take that up? Thank you.
Thank you very much. I think the best way is to go to the website of the arbitration institution and copy the arbitration clause to it, because to your arbitration provision, and then you try to improve it based on the party's wish, how to achieve the impartial and objective award. And even it is a cut and paste, it is a very important clause, and you have to pay attention to. So if you start blindly copying a lengthy arbitration clause in another contract, chance that is not compatible or is not workable with the arbitration institution that you are with. So I give you an example, and it's also related to another question. Can you apply VIAC arbitration and rule by UNCITRAL rule? I think it's tough, because if it is in Vietnam, because the arbitration law in Vietnam say that institutional arbitration is the arbitration run by the institution and under its rule, not under UNCITRAL rule. And then they say ad hoc arbitration is the arbitration ruled by the rule set up by the parties. So I think a better way of if you want to apply UNCITRAL rules and using VIAC as a center, you have to be mindful that it should be not an institutional arbitration, but ad hoc arbitration, and using VIAC as the appointing authority. That would work. So you have to draft that the contract, a dispute will be settled under the rules of UNCITRAL with VIAC as an appointing authority. It's the same effect, but if you don't draft it properly, it would lead to the arbitration clause that is contrary to the arbitration law. So that is my advice. Cut and paste, but be careful. Yeah, and also then you have to be mindful about how you want to appoint the chairman, because the chairman is also very important. So I often see the arbitration say that each party will appoint one person, but the third person shall not be the nationality of either of the parties. So if Vietnamese and US, then the chairman cannot be a Vietnamese citizen or US citizen for the sake of impartiality. And you also have to be careful about the language of arbitration, whether Vietnamese or English. It's very important because it depends on the number of evidence you have to produce, the number of translation you have to produce. Sorry.
Yes. May I add a little bit, Ms. Yeah. Regarding, the parties that want to, choose VIAC as an institution and apply the UNCITRAL rules. It actually happened in one case at VIAC in 2016, yes. And yes, as Dr. Nate have just mentioned, it is not an institutional arbitration proceeding, no. It is considered under the laws on commercial arbitration. This is ad hoc, and sometimes, of course, right. And in practice, at that case, the awards render at the conclusion of the proceeding have to go to the court for the registration under the law, and the court was very supportive at that time, and of course at that time the dissenting parties want to cancel the award, but the awards were upheld by the court. So I think it is very good practice for the party. But again, I totally agree with Dr. Nate that we have to be very well aware of all the legal consequences of that option.
Yeah, thank you, Hằng. So yeah, so so that's also the things that arbitration, the chairman, the parties even agree on how to select what is the criteria of chairman. Is he from civil law or common law, or is he not just nationality? What kind of experience does he have? So the more it is clear, the better you may have the tribunal in the end, because the arbitration is only as good as the tribunal it is. So I would be very encouraging the parties to pay time and effort in drafting a proper arbitration clause.
Thank you, Doctor. I think you've managed to answer both questions intended for you in the Q&A section. The next question, I think there's one person who's been raising his hand for a while. So I think I'll let the Secretariat to let them turn on the microphone and speak directly to the panel to raise the question. Hằng, can you help?
Yes.
Ms. Ha, could you please share more about the witness cross-examination in arbitration? I am a law student and I could only visualize about that process through watching movies. It is the same, I mean the tension in the examination. And also, Mr. Edmund, I know that you're based in Singapore where the arbitration is very advanced. Could you please describe more about such procedure? Thank you.
Well, thank you for your question. I think the subject was covered extensively by Edmund in his presentation, but But I'll leave it to Edmund to add anything further than you wanted to add for the question that I call on her to from the Vietnam perspective. If she has any comments. Thank you, Edmund. Over to you.
Thank you, Hop. The first thing I want to say is don't believe everything you see in the movies. There's a lot of stuff you see in the movies that doesn't actually happen in real life. All that stuff that happens on Suits, it hurts me sometimes. It's painful. It's wrong. It's rubbish. In cross-examination in arbitrations, that tension is there, but it is not an angry process. It is not a fighting, arguing kind of process like you see on television. And in fact, comparing court to arbitration, cross-examination in arbitration is a lot more polite. It's a lot more civil. It's a lot less rude. Some lawyers are very rude in court to the witnesses. You can't do that in arbitration. And the whole purpose is to get the witnesses answer on certain points, right? So like I said, just forget about what you see in the movies. Cross-examination doesn't have to be cross. It doesn't have to be angry. The heart of cross-examination is asking the right questions with the right words in the right sequence to get the answers favorable to your case. There is a technique to this. It's going to take too long to explain all of that. But the starting point is you ask yes/no questions, like I've shown you in the example. Thank you.
Thank you, Edmund. That was very, very helpful. Can I now turn to Ms. Ha for her perspective on this issue? And while I've got you there, Ha, on the floor, maybe you can also address another question that's been put up in relation to lack of cooperation amongst the parties, which I highlighted in my presentation. As a counsel, do you have any solution to resolve this issue of lack of cooperation amongst the parties? So thank you, Ha. Over to you.
Thank you, Anh Herb, for giving me the floor, and thank you for the question. Regarding the question on the cross-examination, I think that whether it is tense or not, it depends on which role are you playing in the hearing. For example, the witness may feel that the cross-examination is very tense because they will be asked with a lot of questions one by one, and especially with the leading questions. But in general, I think that it is not as tense as in the movie or in the litigation proceeding. And secondly, regarding the questions on the how and the question on
the lack of cooperation.
Yes, the question on the cooperation of the parties. And I think I agree with the audience on the point that the arbitration style in Vietnam is affected a lot by the litigation in which the judge handling the case will have a control over the proceedings. However, arbitration is totally different because we have the principle of party autonomy. Like to the extent that they allow the parties to agree on, and the parties should be more active in participating in the arbitral proceeding and exercising their rights. For example, in the collecting of evidence, as provided by the law, the parties have the rights and obligations to invite the witness to support their case. However, the arbitral tribunal have the right, but not the obligation to order the witness to present the evidence. So the parties should be the one who exercise their rights to best protect their case. And regarding solution, I think that lawyers and counsel should be getting involved in the arbitration more, because as far as I remember from statistics of VIAC, not so many cases have lawyers involved in the arbitration proceedings. So I think that having lawyers involved will have the parties will have more cooperative if we have arbitration lawyers involved in.
Thank you, Ha. Thank you, Ha. Can I also on the subject of getting the lawyers involved and getting more cooperation? Can I hear from Edmund and Dr. Ned also, as counsel, how do you enhance this cooperation amongst the parties, especially when you've got someone who just refuses to cooperate from the other side? Edmund, what would you do?
Hope you always ask the most difficult questions.
Only to you.
What happens when you have an irresistible force against an immovable object? It's not easy. It's not easy. I mean, you generally know one another in the arbitration community. The lawyers know one another. So, you know, if today I'm mean to you, I'm unreasonable to you, I'm nasty to you, it's going to come back and bite me in another case. So there's no point, you know, being unreasonable. But I think it's a question of sometimes picking up the phone, talking to the other side to say, okay, this is a proposal. Let's not deal with it as to whether it comes from me or my client or from you. Do you think this is a good idea? Then you don't have to worry about backing down or anything. Let's just work out how we can do this in the most efficient way possible. With the least amount of tension. And I think that generally gets things going. People are sensible that way. But you have to get across that just because you agree with a suggestion that I'm making doesn't mean you're weak, doesn't mean I think you're weak, doesn't mean that, you know, I can get whatever I want. No, I think we understand one another. We are just trying to find the best procedure forward.
Thank you, Edmund. Dr. Ned?
Yes, thank you, Hope. I think this thing is that you have to be officially appointed as the counsel. And after being appointed as the counsel, you should take initiative to get permission from the client to talk with the other counsels. And as soon as you have that, I think I would be encouraged to pick up the phone and call. And don't send email, because the email can be read in many tones and it's too formal and it doesn't get into an agreement. So we just say that, okay, look, this is the case. I understand this is what you want. This is how we see it. Is there any way that we can make it more efficient and agreeable? So that is doing by phone call is good. Now, the point number one. Point number two, try not to raise tone during communication conference with the tribunal, because if you raise tone accusing the other counsel as sloppy or uncooperative, then the other counsel, they may do the same thing to you, and then it's not gonna be good. I think it's trying to avoid that, and sometimes by trying to impress the tribunal that the other counsel is not cooperative, it may be counter-effective, because in the end, what the tribunal see is you are not. Because by the fact that you are using that tone, you are not cooperative. So, in communication, you may, even when you challenge the counsel or you challenge the tribunal, one of the tribunal arbitrator, you just focus on the fact and not on the opinion. And if you just focus on the facts, then things not going to be sidetracked. Yeah.
Thank you, Annette. That was very helpful. There are two questions here in relation to an arbitrator. I'll take on those very quickly, and then we'll go on with the other question. The first question is about this concept of pocket judgment in the Vietnamese court, which means that someone comes to the judge goes to the hearing with a pre-written, closed, signed, and sealed judgment in the pocket, and therefore the hearings may become irrelevant. And so the question was, when I was talking about writing the award early, is it the same thing? Well, it's not, because when you draft the award early, you're simply doing your homework early. As long as you keep an open mind, you can come to the hearing and change everything that you've written. That's fine. And as long as you keep an open mind, that is not called pocket judgment, is the meaning that was intended. And so it's simply a matter of homework, doing your homework, having a draft. That's all. But I'm pleased to report that, at least as a full-time arbitrator, and you've got the ability to achieve more work-life balance if you wanted to. I mean, if you run 100 cases in a year, then it's not. There's not such a thing. But at least you've got the choice there if you want to. Maybe it's a bit different for counsel or people who combine both counsel and tribunal practice. And there was, I think, then next question, and this one might be for Edmund. I have heard about cross-examination, but have yet to imagine what it actually is. Well, we've explained that. Is it similar to the deposition thing in the US or witness examination at courts in the US? Are there procedures, traditions similar to each of them? Do you have any view on that, Edmund? Deposition and
yeah, just a very quick answer on that. A deposition, I'm not a US lawyer. This is what I understand based on my interactions with US lawyers. In some cases I've done. A deposition is basically taking evidence from a witness outside the courtroom. Let's say in a meeting room, in a law firm office. The style is roughly the same because you will be asking questions and those questions are going to be recorded. The style of questioning in terms of asking leading questions could be very similar. What you see in a US court in cross-examination with asking leading questions in cross-examination would be very similar to international arbitration, except in the movies, again, that you know we all have seen, they make it sound like the lawyer is being very angry, very aggressive, very frightening. That's not necessarily the case. You could be speaking like this in a very measured tone and asking the question and the witness answering the question in an arbitration, right?
Thank you, Edmund. Now there are two last questions and we'll wrap that up. And I'll say in advance that if somehow as a moderator I have managed to miss any question, and then I take the responsibility, and please contact me directly and we'll try to address that separately offline. But the last two questions, one comes from Mr. Chen Minh from Vietnam. He's got two sub-questions. The first question is, how important are witness statements in VIAC proceeding? Does a VIAC tribunal attach significant weight to the witness statement? That's question number one. Question number two is, it is ideal to submit a simple SOC similar to a notice of arbitration as opposed to a comprehensive one, and then to follow up with a more comprehensive one later. Okay, can I ask maybe both Edmund and Dr. Ned to address the first question on the witness statement. If you, as if tribunal member of the VIAC, if you receive a witness statement, do you attach much significance to it, Edmund?
I don't think there's a reason not to attach significance to it if it's made by the actual witness and signed off by the actual witness. But you have to look at the witness statement and its contents. It really depends on the contents. It really depends how persuaded you are by how the evidence is presented in the witness statement. I mean, if the witness statement is talking about things that happen at a meeting where the witness was not there, then the witness statement is not very, very useful because he's reporting something that somebody else told him. But if the witness was actually there and he says, I was there, these were the people who were there, this is what they said, I heard this with my own ears and I saw this with my own eyes, and he writes all that out, then the witness statement is very useful.
Thank you, Edmund. Dr. Ned?
I also agree with Edmund. I think the witness statement is good, but provided that they have to be there at the hearing. If they are not there, I would tend to not to regard it. But sometimes they are ready to be there, but the other counsel say it's not necessary to cross-examine then I would pay attention to that. And I would think they agree with what is written in the witness statement like this. So that also depends on how the counsel on the other side would look at it. I saw my experience in some VIAC case that I request the tribunal that the witness has to come, but the tribunal say it's not necessary. And then in their word, they still refer to the statement of the witness. Because VIAC rules is not specific on that. So it's hard for me how can it can be used at the witness, but that's just one of the case what I faced. Yeah.
Dr. Nett, could I just jump in there and say, well, if the witness doesn't attend, then the tribunal shouldn't be looking at the witness statement, because there's no way unless the other side says, I don't have to ask questions on the witness statement. Completely agree with you. The witness should come, and the tribunal shouldn't just say, this witness doesn't have to come. It's not up to the tribunal.
Yep.
Thank you, Edmund and yet. The second question I think is a bit more tricky, because here we, unlike the SIC rules, which contemplate a notice of arbitration, a simple one to start with, to be followed by more comprehensive submission a bit later, the VIAC rules and the law of Vietnam does not contemplate that. It only provides for one step of statement of claim followed by the statement of defense. Therefore, would you advise for or against submitting a very simple notice like what you would do with the SIC, and then asking to put in a more comprehensive submission letter, or would you prefer to put in the entire big box of documents from day one? What would be, in your view, as counsel, and what would be the risk and the problem? I think it's a serious practical problem at stake. And even that, can we start with you, Edmund, and then Dr. Nett?
Thank you. I think it is important to follow the rules in whichever center, whichever country that you are operating in. So if Hop, you've said it accurately in terms of Singapore, the request for arbitration is usually very short. Then the SIAC rules say the parties are allowed to put in statements of claim, statements of defense later on, because that's what the rules are. But in VIAC, if the rules are not that way, then you follow the rules of VIAC and you put in a more comprehensive statement right at the start. If the law of Vietnam says you put in everything at the start, you put in everything at the start. You don't say, oh, I'm from Singapore, I follow the Singapore style. No. If you agree to arbitration in VIAC in Vietnam, you follow the rules of Vietnam and of VIAC.
Thank you. Thank you. Dr. Nett, and then Ha, if any.
I totally agree. Yes, I think it is a big mess if one party submit just say answer, and the other party submit the whole comprehensive of evidence. So it's like one party strip off everything, the other party is still fully covered. So that's really a big mess, and the problem of it is who's to blame. I think the tribunal is to be blamed if they are not very clear about the procedure and make the party misunderstood.
Thank you, Annette. Ha, any comments on that as counsel? Have you ever done a very simple statement of claim, so to speak, in the VIAC context, or do you always put in comprehensive statement of claim as per the practice?
From my experience, I think that I agree with Mr. Edmund and Mr. Nett that the rules must be strictly followed. But in some cases where the claimant has very limited time to prepare the request for arbitration, I think that in the VIAC rules, it is specified very clearly which should be included, and for the legal grounds that request by the request for arbitration in the VIAC rules, I think that a simple article of laws should be included, and then maybe and then it should be sufficient for the legal ground. But in any case, I still advise that for the VIAC rules, a comprehensive statement of claim is important, and in order to be avoid the challenge, it should be prepared from the beginning.
Thank you. So, and my only addition there is that if you do have to go for a simple one because of time constraint, make sure that you very quickly ask the tribunal to have a preliminary meeting very urgently to set out the process, and then ask for the right to put in a big case, a big document to which time or whatever time you need. So have control of the proceeding. Don't just sit there and wait for a summons. Having filed a 2-page statement of claim and then receiving a summons to a hearing 10 days later is not something that you would want to go for. The final question, and it applies to each panelist, could you please identify one subject of high priority for Vietnam to adopt or adapt an international arbitration practice or procedure? Just one single point. What would the most important thing that you would recommend for Vietnam Tribunal and Counsel to adopt or adapt going forward? Can we start with Edmund and then Dr. Ned and then Ha, and then Hang and then myself? Thank you.
I would suggest cross-examination. I found cross-examination as the tribunal to be a very, very useful tool to get to the bottom of things, to find out what the truth is. And, you know, I sometimes wish that the witnesses would be cross-examined properly so that my job as a tribunal is a lot clearer. Thank you.
Thank you, Edmund. Dr. Ned?
If I can say, not the rules, but the law, we have to have the appeal system for setting aside of the arbitral award, number one. And number two, we should not be too strict on the time. Let's say 30 days after the final hearing, there must be an award. And then 14 days after appointing the arbitrator, you should have the chairman. It's not happening like that, because it's very important to appoint the chairman. And within 14 days, how could it be possible to want to challenge or review the CV and change the candidate and so on? Same for the final award. So we should, if that is the time, it should be indicative. It's not a strict time. Thank you.
Thank you, Annette. Ha, what would be your most important thing to incorporate?
Yeah, I think that I agree with Mr. Edmund on the cross-examination, but in order to facilitate the cross-examination, I think that witness statement is also very important, because without the witness statement, there will be no basis for the cross-examination. Because I find that in Vietnam, the parties are not really familiar with the preparation of the witness statement. Instead, the witness suddenly appeared in the hearing, and then it would be very difficult, not only for the arbitral tribunal, but also for the counsels of the parties.
Thank you so much. Hang from the VIAC, what would be the number one?
Yeah, I'd like to take the chance that Dr. Hope asking me about what I want. I want to dream big. I want that I really think that the ancestral model law of arbitration should be adopted fully in Vietnam. I think that the standard legal environment will help the whole system. I mean, the whole market to move forward. So VIAC as one arbitration institution in Vietnam, and also the community of the lawyers and the community of the arbitrator can develop on that advantageous base grounds. So I like to dream big, and I understand that there's the law on commercial arbitration 2010 is now on the plan to be revised by the National Assembly. So I hope that there will be a lot of change, good change for the arbitration in Vietnam. Yeah, thank you. And Dr. Hudson, I understand that this is the last question, but I have just been a very interesting question that I have just put into the answer column. But there's an audience asking, how is your work and life balance like an international arbitrators? I'm so curious too. So can you have 1 more minute for that question, please?
Okay, I touched upon it, but we can always go back to it. I think we probably the question merits more time from all of us. But before that, I just finish up on this question of the, each panel is giving one point that we should incorporate. And my point is about organization of the proceeding. I mean, every proceeding should be organized very clearly and to avoid surprises and unexpected events along the way. So that's my number one point. Moving on to the work-life balance of an arbitrator, or so we'll go through it one by one. I remember last time when somebody invited me to a seminar on work-life balance. My answer was, "I'm sorry, I'm too busy. I couldn't attend the seminar." And so that's my take on it. But anyway, let's go through each one by one. As an arbitrator, what is it like for you, work-life balance? Dr. Ned, we'll start with you, then Edmund.
Yeah, I think that's the best question today. The work-life balance is when it achieved when your work becomes your life. and also because it is hard work, so you couldn't bear it unless you love it. So you love your work, then you have a work-life balance. Thank you.
Yes, Edmund.
I'm still trying to find work-life balance. So I can do many things, but I can't answer that question. I'm still trying to find it as well. And sometimes you have to be an arbitrator, sometimes you have to be counsel, and sometimes you have the rest of your life. So it's not just work and life, it's what kind of work, arbitrator work, counsel work, and life. Still trying to find it. Sorry, don't have the answer for you.
As for me, I still remember that when I was legal practice and an arbitrator, I remember that I would, for all of the holidays, my wife and my kids would be on the beach and I'd be in the hotel room, paying a lot of money per day to use the swimming pool and everything. But I was there writing every award over, all of my weekends and Christmas break was all on the awards and everything. So, and I was still behind, right? And so the pressure was enormous. That's, but as Ned was saying, if you love it, you just do it. I much prefer to do that, to be on the beach, to be honest. At that time, not now, but at that time. So, but just to share with you, when I became a full-time arbitrator, I do have at least more control on my timetable, because you can do as a tribunal member, as a counsel. At least you've got the luxury of being able to sort of, detecting is not the right word, but you know what I mean, and you can sort of have a more predictable timetable to work along. So the pressure is a bit less there. So anything else that on that question from anyone else? Then if not, I think Ms. Hang, can we close, or is there any other matters we need to deal with?
I think it's good now. I think we have just received a lot of thank you from the audience, and I'm so happy now. So I'd like to invite Dr. Herb to wrap up, please. Thank you.
Well, number one, I just do the usual formality, but with full sincerity. I'd like to thank the VIAC for having organized this very useful event for all of us to be here, and I'd like to thank all of the panelists. I know you're extremely busy. Edmund was saying, and Dr. Nick was saying, work is our life. And so, but on a Friday afternoon, I'm sure you have a lot of deadlines looming large on you, but here, spending over 2 hours with the community in Vietnam, which is very much appreciated. I'm sure we have all learned a lot from you, and look forward to having you with us again on future events. I'd like to thank all of the audience or the participants. I mean, without you, this seminar wouldn't exist. So thank you so much for your participation. That I hope you continue to support VIAC and the entire arbitration community in Vietnam and in the world. And as they say, see you in the profession. Have a lovely weekend and see you later. Thank you very much. There's a poll that's just been put up on the, I've seen on the Zoom platform. I'd be grateful if you can spend a minute with that. Go away. Thank you very much.
Thank you.
Have a pleasant evening. Bye-bye.
Thank you all. Thank you, Sop.
Thank you.
Okay.
Thank you, Edmund.
Thank you.
Bye-bye.
Bye-bye.
Bye-bye.